Well, thank you all for coming here. I'm very excited to be at this conference. I think it's a very momentous occasion, one that's long overdue, but I'm heartened to see your commitment to these important causes. Now, I actually normally don't like to read from a speech, but in this case, the events I'm describing took place when I was about 15 and 16 years old, so I think it's better told through the analysis and recollection of my father, Sami Al-Arian, who actually lived these events and was able to talk about them in much more detail. And the events I'm talking about is, as Brother Mahdi mentioned, the campaign to ban the use of secret evidence, the unconstitutional use of secret evidence, which was one of the first fights that really brought American Muslims together, civil libertarians together. And I think the example of how this battle, this legal and political battle happened and how they prevailed is really one that's very relevant to us today, and that hopefully we can take something from it and build on it and be inspired by the story. And what I'm going to talk about is the experience of the National Coalition to Protect Political Freedom, an organization with a very similar name to ours, but which preceded us and who worked on the use of secret evidence. And their story is one of determination and persistence by diverse groups and individuals who joined together to resist repressive government legislation, tactics, and actions designed to punish political speech and association. For a number of years before 1996, the FBI and other government agencies, such as what was then called the INS, or the Immigration Naturalization Service, were pushing Congress to pass a law that would criminalize First Amendment activities centered on support of political groups in politically hot areas like the Middle East and Northern Ireland. In the aftermath of the Oklahoma City bombing in 1995, these efforts accelerated, culminating in the passage of a bill in the Senate a month later with an overwhelming majority, that's 98-1. The law was named the Anti-Terrorism and Effective Death Penalty Act, and although it was facing some resistance in the House of Representatives, it passed overwhelmingly in the Senate, because Senator Bob Dole, who was a Republican majority leader at the time, had presidential aspirations. So the law was quickly passed in the Senate without much debate, as its sponsors exploited the fear, hysteria, and high emotions engulfing the public following Oklahoma City. In the summer and fall of 1995, there were several meetings by those concerned about the law to discuss an appropriate response. These discussions involved my father, Sami Al-Arian, Georgetown constitutional law professor David Cole, the Center for Constitutional Rights, and we have representatives from CCR here today, and others, including some Muslim and Arab groups who were concerned that they could become the targets of the law because of their political beliefs and associations. The executive order issued by President Bill Clinton in January 1995 had precipitated the targeting of political activists, especially those who were critical of Israel and the Oslo peace process. After some debate and in the heat of that year's presidential campaign, the legislation passed the House in April 1996. That same month, the INS arrested an Egyptian Muslim named Nasser Ahmed during an immigration deportation proceeding and held him under secret evidence. This case was the first time the government had invoked the use of secret evidence. Basically, it was a constitutional violation, as it denied the defendant his Sixth Amendment rights to due process. In essence, the government would meet with an immigration judge behind closed doors and without the presence of any defense lawyer, the defendant himself, and provide that judge with secret evidence, which in many cases was hearsay or political associations hyped as support of a terrorist group. The judge would then ask the detainee to defend against it without telling the detainee what the evidence was, which was clearly an impossible task, or as my mom and dad liked to say at the time, it was like fighting ghosts. After the passage of this law, the tactic was used more frequently. So between April 96 and April 98, the coalition documented 29 cases where defendants were held on secret evidence in immigration courts. 28 of them were Arab and Muslim, including the elected Algerian political leader Anwar Haddad in December 1996. In May 1997, my uncle, Dr. Mazen al-Najjar, a Palestinian refugee scholar who'd been living in the United States since 1981 and living in Tampa, Florida, was arrested and became another casualty of secret evidence. Immediately, a local group called the Tampa Bay Coalition for Justice and Peace was formed to lead the struggle to free him locally. For the next 2 months, and through the efforts of many individuals and organizations, a national coalition was formed, which Brother Mahdi spoke about, in July 1997 in Washington, D.C., called the National Coalition to Protect Political Freedom. It included not only many local defense communities of the Arab victims of secret evidence around the country, including Tampa, New York, New Jersey, Detroit, California, Northern Virginia, but also North Irish defendants who were threatened with the same unconstitutional practice until all of them were freed, these Irish defendants, as part of the political settlement of the Good Friday Accords in 1998. The coalition also included traditional, civil, and constitutional rights groups like CCR, the National Lawyers Guild, the First Amendment Foundation, as well as many Arab and Muslim groups, including the Arab American Anti-Discrimination Committee, the Arab American Institute, American Muslim Alliance, the American Muslim Council, CARE, MPAC, MAS, and others. My father was later elected as the coalition's first, and as it turned out, only president. More than 30 groups would eventually join. The coalition agreed to launch two major national campaigns in its attempt to confront the use of secret evidence. One of the campaigns, and other abuses, one of the campaigns was titled Secret Evidence, and the other one was a longer-term campaign challenging the material support provision in this 1996 law I talked about. The interesting thing is the coalition itself coined the term secret evidence, because before that the government was calling it classified evidence. So it shows you the power of language and how coalitions and activists can actually force the U.S. government itself to change its own language. So by the year 2000, everyone was calling it secret evidence, from politicians to journalists to judges and even government agents and prosecutors. The coalition started its campaign against secret evidence for the next 4 years on many fronts, and we'll get into those. As you can see on the board, there's public education and community outreach, the media, support of victims and their families, and it eventually culminated in political lobbying and congressional legislation. In the material support campaign, there was much less effort because it hadn't been used by the government at the time. But if all of you in this room heard about the Humanitarian Law Project and the lawsuit against the material support provision recently in the Supreme Court hearing, this all came out from this coalition's efforts, which basically the Supreme Court a couple of months ago upheld in a very important and critical decision, the criminalization of so-called material support, which could be anything from, as David Cole said, Jimmy Carter basically monitoring an election in Lebanon. If Hezbollah is involved, he could be charged with material support. So this is a very important Supreme Court decision. If someone gives advice to an organization that's been designated as a terrorist organization and tells that group to adopt peaceful, nonviolent means, they could still be arrested on material support. So this is an issue that we should all be concerned about.